I chose the rose. But we made it, and we didn't put enough roses in it.
We only put like 2 or 3.
2 or 3, and then we think we need like
6.
I have a bunch. 1, 2, 3, 4. I have 6. I have 10. Okay. So I'm gonna give it a try. We'll see what happens.
It's been a day.
It's been a week.
It's been a week.
It really has. Okay, some of the things that I've noticed this week is we have people who want to hire us but don't want to follow the process.
What is that? Why do people not want to fill out an intake form?
I don't know. Okay, so our intake forms are intense. They're about 22 pages long, and I understand that. So our process is we like to give people time, however much time they need, before their meeting to completely fill it out.
Well, and it is long, but it actually is shorter than people think. It looks intimidating being 18 pages, but it's the first section is just your name, your address, your basic information.
Right.
The middle section is your values. Give a number, 1 through 5. What's important to you? And then the ending section is just what you have. And why do we need to know what everybody has? Why is that so important?
Okay, so it's not the numbers as much as it is the type of asset that it is.
Right.
So then we know how to treat it, or how to get it into the trust, or how it's going to be treated if there's just a will. We need to understand that. And we also need to understand whether or not they have a taxable estate.
Right.
And so we want to see the bottom number. And I see a lot of people with these, and I think people are private with their numbers, and I understand that. But I couldn't tell you anyone's net worth because I don't internalize it, and it's not important. It's only important if we have the question of a taxable estate. They have a taxable estate. Otherwise, I don't care if you have 100,000 or I would say 100 million, but that'd be a taxable estate.
Well, it also becomes important because we compile, in estate planning, we compile for our clients that spreadsheet, but that goes, it's for them.
It's for them.
Their executors or trustees, whichever they go with, to know where to look for things.
Right. And that's the main point, is so that assets are not lost. Because if you have assets that are not accounted for and your family is unaware of their existence, then it's cheap to the state. They could wind up going into the unclaimed property, and then it takes an act of Congress to retrieve it.
Literally.
Because it really is difficult to retrieve those assets out from the state. And I think the state really wants to keep it.
Yeah, I mean, that's why they make it so difficult. You have to stand on your head and hula hoop.
Exactly.
Do all kinds of things just to get your unclaimed property, even if it's like $20.
I don't want anybody to quote me, but I think what they have in unclaimed property right now is $4 billion.
I thought it was
with a B, 3 or 4 billion. I don't know. It's a large number.
It's at least in the millions, if not billions.
Oh no, it's in the billions.
It's in the billions. Okay.
It's not millions. It's a lot of money.
Jeez.
And they do. They act as if they want to return it.
But they bank on the fact that it's too difficult.
And most people don't go even looking for it there.
Right.
Okay, so I have had cases where we didn't even know something existed, like mineral rights or oil and gas interest, because the parents never told the children, and then they were both gone.
Right.
And the only way we found out was because there was a letter from an oil and gas company that clued us in that there was something, and then we did a statewide search to find it. And the client is like, I didn't even know they had that.
Of course you wouldn't.
The reason we have the forms and the reason we ask for a lot of information is so that when something happens to you, not if, when, everything you own can be located, and no one is digging through your papers, trying to figure it out. Some accounts are open, some accounts are closed. They don't know the state of them. And so that's why we give you a nice spreadsheet. We put everything on the spreadsheet that you tell us about. If you remember something later, that's fine, we'll add it.
Right.
Okay, and that's part of our
you're
process.
looking blindly.
Right. So after they fill that out, then the next process is let's get you on our calendar to come in, or to have an online session where we go through everything. Everything's explained to you. We talk about you, we talk about me, and we talk about what it is that you want to happen when you die, because you're going to die. Everybody's going to die. That's one thing you don't have an option on.
Right. There's only one way we're getting out of here.
Exactly. You do have options. You can either be cremated or buried. You have options how you want to go. I guess some people could be plasticized and used for science or something, whatever.
But you do have
a choice. But you do have to leave.
Right. You must go.
Exactly, at some point. And so it's your choice on how you want to leave your assets and how you want to help your family. And so it's just really helpful to have all of that information.
Right.
And so once they come in and we talk about it and we decide what's going to work best to get your assets transferred the way that you want it. And then once we do that, I should be able to, I say should be able to, we're going to talk about everything. And so I basically will know how much it's going to cost at that point. And we give a flat rate. That's it. Walk out the door. Even if I made a mistake and didn't account for some of this, that's how much it is.
For estate planning.
For estate planning. Yes, for estate planning. Not probate. Probate's totally different. That is outright, okay? But we can talk about that. But, so that's walk out the door with all of your documents, everything in place. And if you find a mistake later, you can call us and we'll correct it, because we're not perfect. We try. And we do have systems so that we are, and we have checks and balances. We check each other's work to make sure that things are the way they're supposed to. Or we'll make a phone call. Hey, wait a minute. What do you want here? And sometimes people come in and they're confused, and so I kind of have to help them look at things a different way. And I will draw on the board. I will make diagrams, whatever's necessary, so that everybody understands what we're doing and why.
Right.
And so once we have that interview, then we get you on the calendar for a definite date for signing. And why do we do that? Because it puts everybody on notice. You have this much time to get everything complete.
We all need deadlines to help keep us accountable. So everybody does their homework. You do your homework, we do our homework.
And we all have a flow. We have a flow.
And it's important to get those documents done in a timely manner, because you're not protected until they're signed.
Right.
And in the case of the trust, until it's funded.
Until it's funded. Right. And so our timeline is, once you come in, a month out signing. That's it, a month out. So we know we have a month to collect all the information. Then we work backwards. And then you take over, basically. You send out a form that says, this is the information we have. Is this correct? Is there any changes? If something's missing, this is missing information. Please fill this out.
Right.
Because we can't really get started until we have that particular document back.
And so it's really important at that point, when I'm sending out those documents, that people really take a look through their confirmation of missing information form and make sure and take that opportunity to correct the information so that we can draft things correctly the first time.
Right. Then we take all of us, draft all of the documents, and there are a number of documents. It's not just a trust or not just a will. It's a trust, a will, and incapacity documents, which is about 5. Okay, so we have a lot of documents to prepare.
Right.
Once we get those all prepared, we also, at that first meeting, we give you a date for review. That review date is when you come in, and I will go over with you the terms of the trust. And what I focus on is how your assets are going to flow to your beneficiaries, and any special language that's in there for special situations. You have some specific distributions or bequests or whatever. Then we go over those to make sure that they're correct the way that you want them, and then we talk about it and make sure that's what you want. Because when you come for signing, that's just for signing. It's not for changing. We are not changing documents on that day, unless there's an emergency.
Right.
So
let's keep count. We've got first 2-hour meeting after you've done your homework. Then we've got, from there we set 4 weeks out the signing date, and before that, a week before that, we have the document review meeting where you ask all your questions.
a week or 2. It can be 2 weeks.
Or 2. Well, that's if we set it for further out.
Right.
Because if it's, yeah.
It's kind of difficult. But in any case, if everybody turns their stuff in immediately, then they can have more time in between.
Right.
But we need that week, because if there are changes, I want to make them immediately, because I don't want to forget, or when we go to signing, it should be that final document with all of the changes that needed to be made. Hopefully there are no changes, but the more complicated it is, the more changes that will have to be made after a review, because sometimes we don't always communicate well with what it was that we understand one thing and you meant something else, and that happens, and that's why we do a review.
But that's also why we ask so many questions up front, because we want to really understand the full scope of what's going on. I mean, this isn't just plug and play documents. This is built for you every time. Right.
And there is some language in there that you can find in all of them. It identifies the family. It identifies the name of the trust, who are the trustees. All of that is always in there. So you're always going to have that. But then when you start getting to the distributions, that's when things change, because some people specifically don't want this person to have it, or want it to go to this person in a certain way, or also all of those are very custom. Yeah, those are custom. And that requires me to think. It requires me to word it just right so that it's what you want. So.
And so what about, how can we better advise these people who just want what they think that they want?
What they come in and they think they want something?
Right.
Okay. So one example of that is that sometimes people don't realize what they already have. And so I have to describe what they already have. Oh, they come in and they basically will tell me, this is what I want. Mm-hmm. Yeah, and then I listen to their, okay, so when people come in, I want them first to understand who I am. And then I want to understand who they are in their family dynamics, because it's really important to understand that. And then they tell me what they want to happen.
Right.
But that's where I draw the line, because if you tell me what you want to happen, I'm going to make a suggestion to you on how you get there. I'm going to give you options on how you get there, because there's more than one option. You're in control, I'm not. Here are your options.
Right.
And so that's how I basically handle
within
that.
The scope
within the
of
scope
law,
of what it is, within the scope of the law and what it is that you want. Right.
Sometimes people want things and it's like, well, the law doesn't
exactly.
really
We can't
allow
exactly
for
do that.
that.
Exactly. Yeah. So this is what we can do, and so once we have our parameters, then we can work within there to make things happen.
If there's one thing we can impress upon our audience, it's that we're real people and you're real people, and we want to give you a real experience. We're not just gonna crank out a document.
And I have to say, we're pretty down to earth. Okay, so sometimes people go to attorneys' offices, or they go there and they're really afraid a little bit, you know?
Yeah.
But we're just people. I'm just people. And I try not to be intimidating. We have a pretty relaxed atmosphere in our office. Mm-hmm. And we're going to try to take care of you. That's the point of it. I'm not trying to impress you. I'm trying to help you. So that's my job, is to make sure that I'm giving you what you need, within parameters, of course.
And that being said, everything we put on the intake form that we send you,
we need it.
We need it. I promise we need it. We need all of it.
Right. Yeah, we get a lot of incomplete homework. We do get a lot of incomplete homework.
I don't get that.
Well, okay, so one of the problems is that people don't necessarily want to share financial information.
And we do have a secure server that they can upload to.
Right.
They don't want to
They have a portal. Right.
Yeah.
They can email. They can upload to the portal. Mm-hmm. And it is secure. You know.
As secure as it can be.
It can be, exactly. Right.
Encrypted.
Or you can, some people have come in, they physically come in.
With their documents.
Because they don't want to transmit over the internet.
And that's an option certainly for people who live in Houston, but we could even help people remotely as long as they lived in Texas.
Yes.
And were willing to come in person to sign. That would be the one.
Exactly. You have to come in to sign.
Yeah.
And, I mean, we could do a remote signing, but that's very difficult. And then you have to coordinate all of those things, the witnesses and the notary yourself, and then we'd have to be there via Zoom or something, I guess.
Well,
or via...
courts don't accept the electronic signature on the will yet, do they?
No, they don't. No. So there would have to be ink in the room and actual witnesses and everyone signing, and we could direct traffic from. So there's a way to do it, but exactly, there's a way to do it, but it's a little cumbersome. But it can be done. Okay, so one of the issues that I see when people do come into the office is not just blended families, but it's families in general. So we set up a trust or whatever, and I've seen trust that people already have where there were no guardrails on the trust. And what I mean by that is their spouses, and they have a trust together. And when the first one dies, what normally happens is their assets are set aside in a trust for the deceased person, and then the survivor has a trust that the survivor can use what's in the deceased person trust as much as they're needing or whatever to support themselves.
I think a lot of people don't realize that when they make a trust together with their spouse, that it is technically separate like that when the first spouse dies.
Right, and the deceased spouse, normally their trust becomes irrevocable, which means you can't change anything, but you can use it. And the purpose of that is so that once the second grantor, the second spouse dies, then the assets in that person that was deceased would also go to the children, and it preserves it for them. So the point is to try to preserve as much as possible so that they can still receive from the deceased parent, even though they didn't receive anything at the time of their death.
Right.
Okay, and so what happens sometimes is that person may remarry. And if there are no guardrails there that say, hey, if you get remarried, you have to have a prenuptial agreement that says that this trust stays in place. Mm-hmm. And if there isn't anything like that, then they could absolutely spend the deceased spouse's assets or transfer them to themselves and use it, and then transfer it to the new spouse. And then the children of the deceased person and the spouse, their children don't get it. Right. It goes to the other family, and then maybe that family receives it because that spouse survived you. Mm-hmm. So it's kind of complicated, and it's not just in blended families. That's also a problem with blended families, however. It can be. It just depends, because if you don't have anything, that's when that problem happens.
Right.
Because with a blended family, if you don't have a will or trust or something for your home in particular, you could wind up owning your home with your stepchildren, yes, and then, but you would have a right to live in it, but the half that belonged to your deceased spouse is theirs. So there are a lot of things to consider. There are a number of reasons why you need something, and then there are a number of reasons why you want to have guardrails in your trust, just in case. I mean, I have people come and say, I'm not going to get remarried. I'm not going to get remarried.
But it
and
happens.
Maybe it does happen. Maybe they're not going to, but we don't know what's going to happen tomorrow. Right. We don't know who's going to die first. We don't know what's going to happen tomorrow. We have to have something in the trust and or will that takes care of any possibilities.
Right.
Yes.
I mean, I feel like 70% of the job is thinking about all of the what ifs that most people don't think about.
Yeah, that's my job. to think about what could go wrong here. Mm-hmm. Yeah, and a lot could go wrong.
And that way you know, and that's why you know what they need versus they might think they know what they need, but they don't.
Exactly. Yeah, exactly. I do point it out. The possibility of things or whatever. Yeah. But I've had a number of people come in and they look at each other and are like, there's no way I'm ever going to get remarried. And I just say, okay. I just, what if? Exactly. I just smile and nod. It's like, but what if? And some of them don't care and don't want the guardrail. I give them the option. That is an option. And then some of the other things to consider is, who are your children? I mean, what do they do for a living? Are they responsible? Do they need a little help? Mm-hmm. Would it be better for somebody to help them with their finances and maybe make sure that they're not overspending or misusing?
And maybe a lot of people don't know that that's an option too.
Right.
Like, there's so many things that you can put into the trust to make it do what you want it to
What you would prefer. What you would prefer. And if you don't care, some people are just like, I'll be dead, I don't care. And that's fine. You can just make sure that whatever it is goes to them outright. And that's in a trust. Okay, so with probate, it's pretty much the same thing. Your will, you would probate it, and if it says that this person receives it, they can. You can have a trust inside your probate, but you have to probate to make the trust actually work. So you can have what's called it's called a testamentary trust. So you can put it inside the will. I don't do a lot of those because if you want a trust, let's do a trust. Let's make it stand alone so that you don't have to go to probate. So I don't know, but I leave it up to the person. They can decide how they want to do it. And I've had a number of people come in and they're insisting they want a will. It's because it's what they're used to, and it just, for them, they're like, my kids can take care of it. I'm not going to worry about it. And so, and that's fine. That's their preference. So I don't argue with anyone with what it is that they want, nor try to tell them what plan they have to have. I explain them to them, and then you get to choose.
I think that's another misconception people have, is that you're going to try to, upsell them or something. Like, that's not at all.
Okay, so attorneys are not really good at selling anything.
No. Attorneys are too matter of fact.
It's not my main thing. I'm not trying to sell. I am, but I'm not. Okay,
Yeah,
I am, but I'm not.
You
But I'm
need
not trying to
something if you don't.
upsell. I'm going to tell you the truth.
Yeah.
I have people who come in who don't need anything except some incapacity documents. And if that's what you need,
That's what we'll do.
I'm going to tell you, and that's what we're going to do. Especially as people age, the older ones, oftentimes their estate's been settled a long time ago, and they may have a house and nothing else, some bank accounts, and really not enough to have a lot. They may want a will. It just depends. If they have more than one child, if they have one child, it's so easy. We can make that house go to them without having to go to probate. So there are a lot of options, and I like to look at all of them. And for a lot of people, I like to keep it as simple as possible. I'm not trying to make it complicated. Sometimes it is complicated, and there's nothing I can do about that. But I'm going to try to keep even the complicated ones as simple as I can.
Right.
Because we're talking about people having to administer this after you are gone. Somebody has to pick that up and say, what am I supposed to do with this? The best thing to do is to seek professional help. Go to the attorney and say, hey, this person died, both of the people died, and I have to administer this. What do I do now? And you'll get some direction. It's called the administration of the trust. It's just like the administration of a probate. You still have to go in and make things happen. So you still have to take death certificates to different companies or whatever, I guess your brokers and that type of thing, or maybe the banks. There's work to be done to settle the estate. But once you've done that and everything's working, then it should be okay. If it's a trust that's going to continue, then there's going to be some accounting that has to be done, and you may want to get a CPA to do that.
Yeah.
So they have the ability to hire the professionals that they need to make the plan work. But all that's done in a trust outside of court.
Right.
And that's the T.